Good afternoon, and thank you for joining us today. My name is Samantha Jessner, and I am the presiding judge of the Superior Court of Los Angeles County. I am pleased to be joined today by the court's assistant presiding judge, Judge Sergio Tapia, the supervising judge of the Criminal Division, Judge Ricardo Ocampo, assistant supervising judges of our Criminal Division, Judge Yvette Verastegui and Judge Kevin Rosenberg, the chair of the court's bail committee, Judge Carla Curlin, and Judge Serena Murillo. Finally, I want to recognize the court's executive officer and clerk of court, David W. Slayton. We're here this afternoon to announce a shift in the way the court approaches pre-arraignment release for those arrested for nonviolent, non-serious felonies and misdemeanors in Los Angeles County. That is the period of time between arrest and arraignment. We are confident that our new approach, which I will detail in a moment, will increase community safety and reduce failures to appear in court. In addition, and importantly, for this class of offenses, the shift moves away from a wealth-based pre-arraignment detention system, which rises and falls on one's ability to pay money bail, regardless of risk to the community. Rather, for those arrested for nonviolent, non-serious felonies and misdemeanors, our new protocol will determine release status based on risk and on an individual's circumstances. Low-risk level arrestees will be released pending arraignment based on non-financial terms of release. Before we talk about the specifics of the court's bail schedules, it's important to have an understanding of the purpose of bail. Bail has two purposes. One is to ensure an arrestee appears for all court appearances, and two is to reduce the risk to public or victim safety. Article 1, Section 12 of the California Constitution entitles most arrestees who are presumed innocent until proven guilty, beyond a reasonable doubt, to release on bail while awaiting trial. Consistent with the United States Supreme Court's decision in U.S. versus Salerno, the court seeks with this protocol to ensure for low-risk level arrestees that, and I quote from the case, "In our society, liberty is the norm, and detention prior to trial is the carefully limited exception." Consistent with these foundational concepts regarding our criminal justice system in California, just a few hours ago, the court approved a new set of bail schedules. The new schedules include pre-arraignment release protocols for nonviolent, non-serious arrestees that will maximize safety to the public and ensure equal treatment of arrestees regardless of wealth. They will take effect in Los Angeles County on October 1st. These newly adopted bail schedules will reduce reliance on money bail as a condition of pre-arraignment release for many of those arrested in LA County for misdemeanors and nonviolent, non-serious offenses. Instead, release status between the time of arrest and arraignment for low-risk offenders will be based on non-financial release terms, based on the arrestee's risk to public safety and their likelihood of returning to court. Research has consistently shown that access to financial resources is not an accurate predictor of community safety or the likelihood of returning to court. In fact, a Judicial Council of California report released this week shows that risk-based, individualized determinations of release result in a meaningful increase in community safety and reduces failures to appear for court and trial. The Los Angeles Superior Court's actions today are consistent with this court's and other courts nationwide efforts to refine and think expansively about pretrial release for nonviolent, non-serious offenses. In 2020, the court adopted the PrEP program that allowed the court to make individualized risk-based release decisions for certain arrestees. During the pandemic, the court and many other courts throughout the state adopted an emergency bail schedule pursuant to the judicial branch's emergency rules related to the COVID-19 pandemic. Taking into account the court's experience over the last 3 years and extensive empirical research regarding pretrial release outcomes, including the Judicial Council's most recent report that is informed in part by our court's PrEP program, the court's bail committee has proposed an updated pre-arraignment release protocol. The new protocol reflects an undeniable conclusion. For low-risk arrestees, pretrial release decisions that are based on risk and an individualized determination improve public and victim safety and ensure the appearance of the arrestee at court and trial. Non-financial terms of release for low-risk individuals ensure that this class of arrestees are not being detained unnecessarily and simply based on lack of financial resources. Adding to the context of this announcement is the Urquidy versus Los Angeles matter, where a judge has deemed the court's current bail schedules unconstitutional in violation of the Equal Protection and Due Process Clauses. A preliminary injunction has reinstituted the COVID-era emergency bail schedules for the Los Angeles Police Department and the Los Angeles County Sheriff's Department only. The remaining 50-plus law enforcement agencies in the county were not named in the lawsuit and therefore are operating pursuant to the current bail schedules. The court, similarly, was not named in the Urquidy lawsuit. To put a finer point on this, the preliminary injunction does not apply to law enforcement agencies other than the LAPD and the Sheriff's Department, which has created confusion and a lack of fair and equal access to release to all arrestees in the county based on one's wealth rather than one's risk. It is also important to note that these protocols were not developed in a vacuum. The court is building on the continuum of progress the state, county, and court have already made towards pretrial release reform. The protocols are consistent with the recommendations of the Judicial Council of California's 2017 Pretrial Detention Reform Work Group, of which our own Judge Murillo was a member. The purpose of the work group was, and I quote from the report, to provide recommendations on how courts may better identify ways to make release decisions that will treat people fairly, protect the public, and ensure court appearances. Ultimately, the work group recommended, and once again, I will quote, implementing a system that maximizes public and victim safety, early release, and return to court while minimizing socioeconomic disparities and bias. This system should uphold the right to liberty and the presumption of innocence and affirm that public and victim safety must not be contingent on the financial resources of the accused. The protocols that we are announcing today are also consistent with the goals of Senate Bill 129, passed in 2021, which provided funding for court programs and practices that promote the safe, efficient, fair and timely pretrial release of individuals booked into jail, and assists judges in making pretrial release decisions based on the least restrictive conditions while ensuring public and victim safety. We are proud that our court was one of the first counties in the state to implement a pilot project in 2020, funded by the legislature, that became the basis for Senate Bill 129. That pilot in Los Angeles was also the basis for the Judicial Council's newly issued report, which sets forth in detail the benefits of risk-based, individualized bail decision processes. Let me provide some background as to the court's process for making changes or amending bail schedules. The California Penal Code provides local superior courts with the authority and responsibility to set uniform county bail schedules. These schedules give law enforcement guidance with regard to whether to release or detain individuals who are booked into jails across our county. Traditional bail schedules assign specified dollar amounts to specific crimes, which individuals can pay as bail to secure release, if they can afford the amount of bail. Pursuant to the court's own local rules, the supervising judge of our criminal division appoints members of the bail committee. Annually, the bail committee must revise and recommend for approval uniform countywide bail schedules. The bail committee then submits its recommended bail schedules to the court's executive committee for final approval. The uniform county bail schedules are considered adopted by the judges of the court once approved by the executive committee. Earlier today, the court's bail committee recommended to the executive committee adoption of new pre-arraignment release protocols and bail schedules for nonviolent, non-serious felonies and misdemeanors. The protocols, which were unanimously adopted, reflect consideration of research and data which show that the current pre-arraignment monetary bail system, which bases a person's liberty solely on their financial resources without proper consideration of their risk to public safety or likelihood of returning to court, is not effective in protecting the community and ensuring an arrestee's return to court. As I said, the executive committee unanimously adopted the recommendations of the bail committee, which reflect new bail schedules with pre-arraignment release protocols for misdemeanors and nonviolent, non-serious felonies that ensure due process, recognize the presumption of innocence, protect public safety, and maximize the likelihood of the arrestee returning to court. Pursuant to our local rules, the judges of this court, through the hard work of the bail and executive committees, and consistent with our obligation to uphold the Constitution and promote fair and equal access to justice, have taken a significant step toward pretrial release reform. And now to unpack the details of the new schedules. Under the new bail schedules, nonviolent, non-serious offenses will correspond with pre-arraignment release categories based on the arrestee's risk to public and victim safety and likelihood of returning to court. For misdemeanors and nonviolent, non-serious felony offenses, money bail will not be a required condition for release. Instead, the protocols focus on an individual arrestee's risk to public and victim safety and the arrestee's likelihood of returning to court. This will ensure that individuals are being released on these offenses because the court has determined that the arrestee is suitable for release based on their risk and not simply based on their access or lack thereof to money. For nonviolent, non-serious offenses, instead of assigning an arbitrary money bail amount depending on the nature of the offense, arrestees will be cited and released at the location of arrest, which, I want to emphasize, most law enforcement agencies have been doing for some period of time based on their own internal policies. The arrestee will receive a citation or ticket, which will include an order to return to court on a date certain in the future. This will be reflected as CR, the abbreviation for cite and release, in the bail schedule. Or they will be booked at a law enforcement facility and then released on their own recognizance from the booking station. These are referred to as BR, or book and release offenses. Persons arrested for certain misdemeanors and nonviolent, non-serious felonies who pose a greater risk to the public will be referred to a magistrate for review. The designation in the new bail schedules will be MR. The magistrate, based on additional information, will conduct individualized determinations of the appropriate non-monetary release terms for the arrestee. After consideration of the individual's risk, the magistrate will exercise their discretion to decide whether to release the arrestee with or without other terms or conditions. Examples of terms or conditions that a magistrate may impose include prohibitions on further violations of the law, a promise to appear in court, pre-arraignment monitoring, text reminders regarding upcoming court appearances, call-ins or check-ins to a supervising entity, and/or electronic monitoring. Consistent with the law, consideration of public and victim safety is a key underpinning of this new approach. Persons arrested while out on post-release community supervision or out on parole will not be eligible for cite and release or book and release and will be referred to a magistrate for an assessment. Persons charged with capital offenses or certain felonies designated in the California Constitution will remain ineligible for pre-arraignment release. Pursuant to Penal Code Section 1270.1, persons arrested for serious or violent offenses will not be eligible for cite and release, book and release, or magistrate review. Let me repeat that important fact. The court's action today does not change the way that we address pre-arraignment release for arrestees arrested for serious and violent offenses. These individuals will not be released by the court on $0 bail through cite and release, book and release, or magistrate review, but remain eligible by statute to pay money bail and be released prior to arraignment, notwithstanding their risk level. If an individual arrested for a low-level offense remains in jail at arraignment, the judge assigned to the arraignment hearing will hear from prosecutors and defense attorneys and make a decision about the release of that arrestee. All release terms for arrestees may be reconsidered by a judicial officer at arraignment. Magistrates are available 24 hours a day, 7 days a week. For those arrested for certain misdemeanors and nonviolent, non-serious felonies, magistrates will consider an arrestee's criminal history, consider any past failures to appear in court, and determine the appropriate non-monetary release terms, if any. Magistrates will review cases carefully and with all deliberate speed. We anticipate that 1/3 of cases will be reviewed within an hour of arrest, and 90% will be reviewed within 6 hours. Examples of crimes subject to magistrate review include crimes related to minors, elders, sexual violence, and firearms. To give you an idea of how the new schedules we're announcing today compare with traditional bail schedules, here is a side-by-side comparison of each. As you will see, instead of assigning a money bail amount to each offense, nonviolent, non-serious crimes now correspond with a release category, CR, BR, or MR. Serious and violent felonies, as defined in Penal Code Section 1270.1, still correspond to money bail amounts pursuant to the statutory mandates discussed earlier. The new bail schedules and the protocols within them, one for misdemeanors, one for felonies, and one for infractions, will become effective October 1st to provide law enforcement and justice partners with the opportunity to design and implement systems, procedures, and tools to accommodate the new pre-arraignment release protocols and time to receive training. We remain appreciative of our working relationship with the County of Los Angeles and law enforcement in the county, especially as we have refined and modified our pre-arraignment release processes over the past several years. We look forward to working with the county and other justice partners to implement additional systems and services that protect the public and victim safety, ensure that arrestees return to court, assist citizens in crisis, and uphold the bedrock principle that those arrested for and accused of crimes are innocent until proven guilty. We are now happy to take questions.
We now have a few minutes to take questions from media outlets only. Members of the media, please raise your virtual hand and wait until called on to unmute yourself and ask your question. James from the LA Times, go ahead and unmute yourself and ask your question.
Thank you. So I obviously understand that these new bail schedules will go into effect on October 1st. Can you please explain what will happen in the time period between now and then? Will the injunction that was issued by Judge Riff earlier this year stay in effect for LAPD and sheriff's cases, and then the standard bail schedule will stay in effect for all other jurisdictions? Just please explain how this is going to work between now and the 1st.
So I'm going to start by saying something that I say often, which is the canons, the judicial ethics canons prohibit any judge from commenting on pending and impending cases. So we are very careful about what we say and sensitive to that canon and the prohibitions contained in that canon. I think the short answer to your question, Mr. Quealy, is yes. The status quo will remain until the bail schedules go into effect on October 1st. At least that's what I can say from the court's perspective.
Okay, moving on. We will now move on to Robert Green, also from the Los Angeles Times. Robert, go ahead and unmute yourself and ask your question.
Thank you. I had some questions regarding the thinking that went into the emergency bail schedule and the degree to which it carries over to the new bail schedule. So, for example, under the emergency bail schedule, a person was not eligible if they were already on release for a previous crime. Is that going to be the case? I didn't hear you address that. If that's going to be the case under the new schedule that takes effect in October, that if a person has been released pending was previously arrested and was released, would they be eligible for non-bail release under the current under the new schedule?
So, Mr. Green, let me start by addressing the first part of your question, which you said something to the effect of, I want to understand the thinking. And it's important to understand that the decisions that have been made about the contents of the new bail schedules are 100% within the realm and the duties and responsibilities of our bail committee. And they reflect the deliberative and deep dive process of that committee in promulgating or recommending for promulgation these new bail schedules. As I stated, a person who is arrested for a non-serious, non-violent felony or a misdemeanor who is out on community release or parole will then be categorized and treated consistent with our magistrate review path. And they will take into account that person's status in deciding what the release status should be.
Okay, seeing no further questions, thank you so much for joining. Have a lovely day.
Thank you.